if this. There we go. Well, welcome everyone. Thank you for joining us. As you'll have just heard, this webinar is being recorded and may be published, well, I think will be published on our website. So just to give you that caveat to start with, I'm having a Chris Whitty moment in that Bethan is going to be fast forwarding to the slides for me. What we're going to do in the next 45 minutes or so is talk to you all about common mistakes in Employment Tribunal witness statements. We're going to cover a number of issues, so we'll start with some of the basics and then move on to some common mistakes that we come across. And I should say at the outset that as barristers, Bethan and I have limited involvement in the drafting of witness statements. We tend to come across witness statements as the finished article, and some of them are excellent, but of course some of them are not. And really what this talk is going to do is go through some of the pitfalls and how to avoid them based on our experience. But we do recognise that the drafting of witness statements is not an easy task. So Bethan, next slide, please. So I've read a recent study, I think it was from last year by the Birkbeck School of Law, which specifically looked at witness statements in employment tribunals in England and Wales and how they are prepared and the issues that parties came across. And the study was based on interviews with lawyers, litigants in person, employment judges and panel members. And one thing that struck me from that study was that there were a number of deficiencies in the ways in which statements were prepared and in the training that lawyers in particular had had. A lot of the lawyers that were interviewed as part of that study revealed that they'd never had any training at all in how to prepare witness statements. Some had been trained when they were studying for legal qualifications, but couldn't recall the content, duration or stage in their education that they'd received that training. And then some solicitors said that they'd received some in-house training provided within their law firms. And indeed, I asked a solicitor friend of mine yesterday if she'd ever received any training. And she said, well, no, I just learned on the job and I just get my list of issues and try and work through that as best I can. And I think that's probably representative of a lot of lawyers. And that's perhaps why we see great sort of discrepancies between the content and quality of witness statements from one case to the next. So that begs the question, well, what's good practice? And I think we have to go back to basics here. So slide 3, please, Bethan. There we go. So the starting point is the guidance, and we have first of all the presidential guidance from 2018 tells us that witness statements should be word processed, page numbered, in logical order, ideally chronologically, with numbered paragraphs, covering all the issues in the case. And we're going to come back to that point, and be as full as possible. Now, I should say that employment tribunals in England and Wales must have regard to that guidance, but they're not bound by it. And then, of course, we have the Constitution and Rules of Procedure regulations from 2013, which include at Rule 43, the fact that where a witness is called to give oral evidence, any witness statement of that person shall stand as their evidence in chief, unless the tribunal orders otherwise. And then, of course, finally, that they're required to give evidence on oath or affirmation. So slide 4, please, Bethan. Why prepare witness statements? And we're going to finish later talking about the position in Scotland and my difficulties with cases in Scotland. But I find that witness statements helps witnesses to write down what they're going to say in their evidence, and they often remember much more and feel more comfortable giving evidence having done so. Secondly, early exchange of witness statements helps the parties know the case they're going to meet and what the issues are going to be. And then that helps the relevant evidence come out in the hearing. I often find there's very little to gain and much to lose by withholding evidence or not having that all written down or produced within a bundle. Also, the preparation of statements helps the tribunal identify issues and ensure that the case is completed in the time allowed. And then finally, statements can influence the way in which disputed issues are interpreted. That can have a bearing on litigation costs, efficiency of the way that the tribunal system works, and decision-making outcomes. And that's something, a point that's made in an article by Pender and Heatley from 2018. So slide 5, please, Bethan. The core principles of what principles should follow the preparation of witness statements. Well, gather information about who did what, when and where, gather information which informs an investigation, of course obtain a truthful account. Any statement drafted should be comprehensive and provide a full account of the facts, but with the caveat that statements should be concise without too much superfluous detail, but with recognition it takes skill and time to produce a concise yet appropriately balanced statement. Slide 6, please, Bethan. So business and property courts, I know that this isn't applicable to employment tribunals, but this is quite interesting in that this guidance came into force in April of last year. And it states that all witness statements in the business and property courts must comply with Practice Direction 57AC. And it'll be interesting to see if this filters through to other courts and tribunals. Because what really it's telling us is that there's a sort of cultural shift back to factual witness evidence, i.e. evidence of what a witness actually remembers about relevant events, even when there are gaps in that evidence or controversy in relation to that evidence. And it gives guidance about how to draft the witness statements in the business and property court. So first of all, you'll see there has to be a statement of compliance, not only from the witness, but also a certificate of compliance from the relevant legal representative. And then if we see the 3 bullet points at the bottom, the statement of best practice in relation to witness statements. This really describes the approach of the court to human memory. And I think this often comes into play in the preparation of witness statements for employment tribunals. So first of all, any witness statement should be prepared in a way so as to avoid, as far as possible, any practice that might alter or influence the recollection of the witness other than by refreshment of memory. Secondly, particular caution should be exercised before or when showing a witness any document that they did not create or see when the facts evidenced by or referred to in the document were fresh in their mind. And thirdly, the preparation of a trial witness statement should involve as few drafts as practicable. Any process of repeatedly revisiting a draft statement may corrupt rather than improve recollection. I think that's actually quite a good approach to take in relation to employment tribunal witness statements. And actually, it also concurs with what, again, we're going to come on to later on in relation to tribunals in Scotland. So the suggestion here is that witness statements should be based on an individual's true recollection of facts, and there should be limited interference by lawyers with that recollection. And that brings us on to mistake number 1, and Bethan, you're going to take over with that.
Yeah, so you'll see on the slide, these are extracts from 3 witness statements from 3 different witnesses from a matter that I dealt with fairly recently. And just a very brief reading of those will reveal what issue number 1 is. Copy and paste, or the use of pro forma statements. These statements were used in a final hearing from 3 pertinent witnesses in a redundancy case, where the sufficiency of the consultation and how the consultation meetings were run was a primary issue, really at the heart of the case. And you'll see that really what's happened is the solicitors either had a pro forma already prior to the case, or 1 witness statement's been written, and then there's just been a copy and pasting and a change of names. This is something that we unfortunately see frequently. It's relevant to return to some of the guidance that Sarah's just taken us through, not only the presidential guidance that the witness statement set out fully what the witness has to tell the tribunal, but also I think that having a look at the civil procedure rules practice directions on witness statements is also helpful. Similar to what Sarah said about the business and property courts guidance, of course it doesn't apply directly, but there is perhaps more full guidance in that respect. And of course, those of you who practice in civil procedure will know that the rules for a civil witness witness statement in the county court would be that the statement is in the witness's own words. And of course, if you've got a copy and paste or a pro forma statement, then that quite simply isn't in the witness's own words. And the issue really is that it affects the credibility of that witness and the veracity of their evidence. It is for the claimant, and I say claimant because this often appears in respondents' witness statements where you've got perhaps 3 people who may have had involvement in different stages of the process, copying and pasting the same comments about that process. For a claimant, it's such an easy line of attack. And what makes it worse is if you have a witness who, for example, in the case where I've just shown you those 3 excerpts, exactly this happened. Each of those witnesses maintained that they'd written that statement and it was their own words and they hadn't spoken to anyone else about it. Well, now your witness just looks quite plainly silly because of course those can't be their own words, because it would be incredulous that 3 people have managed to come up with exactly the same comments. So how do you avoid overuse of pro formas or a tendency to perhaps copy and paste bits of witness statements? Well, we can go back to the Birkbeck research. It's fairly dry, but I thought it was quite an interesting read actually, albeit perhaps dry bedtime reading, maybe good if you're suffering from insomnia. But what that research made clear from those who were interviewed is that the use of pro forma statements really is far from best practice. And what it can result in is unfortunately an inauthentic version of the evidence. From those who were interviewed, and there was a range of respondents, including employment judges, solicitors, and barristers, a consensus emerged that really face-to-face interviews are preferable to those over the telephone. And while, of course, we appreciate that can be difficult, perhaps a hybrid approach could be best if, for example, as is often the case in tribunal, you've got one sort of star witness, the most important person, perhaps in an unfair dismissal case, the dismissing officer. It might be proportionate to have a face-to-face interview with them and telephone or video interviews with others. I think the difficulty is, of course, it's obviously far more convenient to take witness statements remotely, but face-to-face, the broad consensus should be preferred. Another of the conclusions that was formed by the Birkbeck research is the importance of having the bundle to hand when preparing the witness statement. And of course, this ties in somewhat with what Sarah said, which is obviously a more nuanced point about perhaps holding back some documents, perhaps the witness having, in essence, their relevant documents rather than the later documents, again, using the unfair dismissal case, perhaps the dismissing officer just having theirs, not having the appeal documents. And then again, coming back to what Sarah said earlier about there being, in essence, one draft or as few drafts as possible. The idea really being that this is the witness's witness statement and they should be preparing their own evidence in as few drafts as possible, in essence, with the solicitor's role being to tidy up that evidence rather than to elicit it or to create the evidence that the witness then confirms they're happy with standing as their own statement. So moving on to the second issue that we've identified, and I should say that Sarah and I identified these separately, but also it's fair to say that these are issues that were also identified within the Birkbeck, or at least in many ways alluded to in the Birkbeck research. So clearly it's a common theme. So issue number 2 is failing to address the issue or the issues. The extract that you have on the slide is part of a witness statement that I was presented with in a PH, a one-day PH on the issue of employee status, and the issue was this individual a worker or an employee? And this, unfortunately, was the body of the statement I was provided by the respondent. There was very little that came before or after the 4th paragraph, which in essence you'll see asserts that the claimant was a 0 hours worker, rather than giving the evidence on the issue of status, simply stating in essence what the respondent's point was or what they the conclusion that they wanted the tribunal to reach. Again, going back to the guidance, it's clear that witness statements need to cover all of the issues in the case. They need to set out fully what the witness's evidence is and be as full as possible. The guidance is clear that it's only in exceptional circumstances where there will be additional evidence to be added to witness statements. Those of you who perhaps do your own advocacy in employment tribunal will be conscious that questions in chief elaborating on statements in employment tribunal, asking supplementary questions, are fairly rare. And also tribunal judges are often fairly harsh on interrupting and certainly challenging when counsel's in essence trying to bolster the evidence or patch gaps in the evidence where really a clear issue should have been dealt with. And of course, there is ultimate burden on the employment tribunal as per the overriding objective to deal with all of the issues in the case. So the witness statements need to be doing that. So how do you stop there being gaps or make sure that all of the issues are covered? Well, firstly, a list of issues is normally prepared at least before the final hearing, either by way of a list of issues in a case management order or separately ordered by the tribunal to be prepared at a later date. I think a helpful way to start with drafting a witness statement would be either go and find whether there has been a list of issues produced, or if there hasn't been, produce one then and there. I said if there isn't a list of issues, it's often ordered to be produced anyway. So really you're just doing that little bit of work earlier, and it's going to save you more work in the future, because ideally you'll have a better witness statement if you're preparing it by reference to that list of issues. If the case is particularly complex, it's helpful to take that list of issues down and break that into the subheadings. And of course, what you could always do is prepare for the witness, if they're going to draft their own first draft of the statement, is simply prepare them a document with each of those subheadings in it. And the witness can go ahead and fill in essence, their evidence under each of those subheadings. What I would urge you never to do is the bury the head in the sand technique, which often we see where there's a thorny issue, a bad issue or a bad fact, as you might say, and the statement doesn't deal with it. That's more often a feature of claimants' witness statements rather than respondents. But clearly, if it's an issue, it's going to need to be addressed. So do it in the witness statement rather than either exposing you to the potential that you've not addressed the issue, or also exposing your witness to criticisms. Why, well, the obvious being, well, why haven't you included that in your statement? So that takes us on to issue number 3, which I think Sarah's going to deal with now.
Yeah, so what do you do when in the run up to the final hearing, one of your witnesses tells you that a key piece of evidence has dropped to the bottom of the North Sea, or perhaps more likely than that, that a piece of evidence is missing from the bundle, or that their witness statement simply doesn't deal with a key point. And that often happens after exchange of witness statements. And we've all been in that position, I think, where despite a client having drafted and approved their statement and signed the statement of truth, lo and behold, in the run up to the hearing, they say, oh, well, actually, there's something missing from here. I had this happen the other week, and really it sort of was the starting point of why we lost the case. So I had a case the other week dealing with detriment. I was for the respondent. Everything turned on what was said in one particular meeting. My main witness gave very brief evidence about the meeting. He said, this is my recollection of it. I took no notes. What the claimant suggests wasn't said. I had a conference with him. I asked him how he could be clear about what was or wasn't said if he didn't have any notes. He said he was going to have a think about it. He went away, and lo and behold, a day or two before the final hearing, he came back and said he'd checked his notes, which obviously none of us had seen, but actually that there were 2 meetings and not 1 meeting. Now, I then had to deal with that on the morning of the hearing by eliciting it in evidence in chief. The tribunal had a lot of questions for this witness about it, and ultimately found that he wasn't credible because he'd added or he'd missed out key information from his witness statement, and that really was the beginning of the end. So the next slide, please, Bethan. What do you do when this situation arises? Well, unless it's a day or 2 before the final hearing itself, draft a supplementary statement for the witness, or sorry, let them draft it and help them with it. Send it immediately to the other side. Put them on notice, put the tribunal on notice that this is an issue, so that no one can say, that they've been ambushed with this information, or a new statement indeed on the first day of a hearing. But also remember Rule 43 that we looked at earlier. There's no presumption that you'll be able to adduce evidence in chief unless the tribunal orders otherwise. Now, I was allowed to in this case, not that it particularly helped me, but I was allowed to. But I know several employment judges that say, no, your statement is your evidence in chief, that's it. And then, of course, the evidence, if it comes out, will come out in cross-examination, which can be even more damaging. So this is why it's so important for witnesses to make sure that their statements are accurate, make sure that everything is their own words, make sure that they have access to all the notes, their own notes and documents that they need to make sure that their account is truthful, so that you can avoid this happening at a late stage. And then I think we're back to Bethan now. Is that slide? Yeah, failure to address remedy.
Yep. So fourth and finally, failing to address remedy. Again, another extract on the slide. In essence, it's fairly commonplace that you get witness statements for both claimants and respondents that fail to address remedy. What I've put on the slide is from it was broadly an unfair dismissal case. And you can see that this was purporting to be sufficient evidence from the respondent to say that the claimant had failed to mitigate her losses. But clearly, if you look at it really, what it is, it's again an assertion that the claimant mitigate her losses. It goes some to making it slightly more specific with reference to the type of work that the claimant was doing, but no real evidence as to a failure to mitigate losses. The first place to start here is checking what's the scope of your hearing, your final hearing. Is it a liability only, or is it liability and remedy? I think hearings generally more often than not are liability and remedy together, but also you might take the view that unless there are particularly thorny remedy issues, perhaps it's best just to get all of your statements dealt with at one time, particularly on sort of broad issues regarding mitigation of losses. Whoever you're for, you need to be addressing liability and remedy. For the respondent, I've already touched on it in regards to the failure to mitigate, but what's important, of course, is that the authorities are very clear, and have been for some time, that just as in civil courts, it's for the respondent to show there's been a failure to mitigate losses. So perhaps the earliest authority on that is Fife and Scientific Furnishings Limited. It's a 1989 EAT authority. So there's really no excuse for dropping the ball in that regard. And what you need to be showing as a respondent is that the claimants failed to act reasonably. What's often referred to is a reasonable job search or a proactive job search. If, as a respondent, you're relying on Polkey, equally, of course, you're going to need to set out in the witness statement, say, of the dismissing officer or the appeal officer, if you have them in your case, what your evidence on Polkey is. Often Polkey is referred to in grounds of response, and then there's no evidence in that regard. I think what sometimes the assumption might be is that opposing counsel will say to the witness, well, Ms. Brewis, you've not addressed this point in your witness statement. But of course, it's not for the other side to adduce evidence that is missing from witness statements. And it isn't for the other side to plug the gaps in your evidence. If the burden's on you to show it, then you need to be adducing the evidence from the outset. Equally, if you're for a claimant, this is perhaps slightly contradictory to what I've just said about the burden being on the respondent to show a failure to mitigate. But I would say for a claimant, you need something on mitigation, because otherwise what you get is the respondent making the point, well, all of this evidence is within the claimant's hands and it's clearly relevant. Often a failure to mitigate is specifically pleaded in a grounds of response. And certainly if it's there in the grounds of response, then it's an issue in the case. If it's there in the list of issues, then it's an issue in the case. And if the claimant has evidence that's relevant to it, you should be addressing it. The relevant evidence would be, for example, setting out what job searches have been conducted, how they've been conducted on LinkedIn, for example, or Indeed, what job applications have been made and when, what agencies have been used, interviews. You can see how by just addressing it in a formulaic but detailed way in a witness statement, you can quickly build a much more compelling case for a claimant to say, I've mitigated my losses, these are the steps I've taken, by being proactive with it and dealing with it in the witness evidence, rather than in essence leaving the claimant high and dry in cross-examination to be asked questions sometimes a year, 2 years later about the steps that they've taken previously. Much better to in essence preempt that attack that your client's almost certainly going to face. And then finally, in respect of claimants, what you often see is claimant statements failing to address injury to feelings. And of course, in this regard, the claimant's evidence is absolutely paramount, because you're looking at what has, in essence, how does the claimant feel? What has been the impact on the claimant? And certainly when you're representing a respondent, if you have a claimant's witness statement that deals very neatly and in a compelling way with the issue of injury to feelings, it's actually very difficult as a respondent to attack. I know certainly from my experience in talking to colleagues about it, often you don't really want to in essence poke the bear if the witness evidence is there, because often then what you get is a witness who then has more of an opportunity to elaborate on what's already in their statement. And it's certainly far more helpful for the claimant to have that again there set out in their statement, because again you're protecting your client from the inevitable, well, why isn't this in your statement, and the inevitable points that may be made about the client's credibility and the veracity of their evidence if you haven't included it. And I think that takes us to a final point on witness statements in Scotland.
Yes, so this isn't a mistake point as such, other than I think a lot of lawyers in England and Wales mistakenly think that they can use witness statements in Scotland. And the position has always been, and will continue to be, that that is simply not the case. So there was some guidance issued just last month by the President of the Employment Tribunals in Scotland, Judge Susan Walker, accompanied by a practice direction concerning the use of witness statements in tribunals in Scotland. The position in essence is unchanged, but this is quite helpful guidance in terms of it sets out 9 factors to consider when deciding whether or not witness statements should be ordered. Now, what parties are told to do is, if you're representing claimant or respondent, if you feel that this is a case that would benefit from witness statements, you should apply to the tribunal as early as possible in the proceedings. That will then go before an employment judge. He or she will issue a written decision. So it's very formulaic in terms of how it's dealt with. There is no presumption that you will be able to rely on witness statements, and it will be decided quite early on in the proceedings. In terms of the 9 factors, they're fairly restrictive. So just to go through them quickly, and these are what the tribunal will consider in deciding whether or not it's appropriate for witness statements to be used. So first of all, whether or not the parties have expressed a preference one way or the other, and whether or not ordering witness statements will present a practical or psychological hurdle that's difficult to surmount for either party. Secondly, whether ordering the use of witness statements will assist the tribunal in its duty to make reasonable adjustments or accommodate the needs of one or more witnesses for whom English is not their first language. Number 3, where all parties are professionally represented, cross-examination may play a particularly significant role when statements are used, and a skilled legal representative is likely to find that task easier than an unrepresented party, therefore giving the represented party an advantage in the proceedings. Number 4, the capacity of the parties to produce witness statements, because some unrepresented parties may find it difficult to write down their own evidence, for example, let alone take statements from any witnesses they may have. Number 5, the practical resources available to the parties, including access to a word processor, email facilities, supplies of paper, etc. Number 6, whether there are factors that suggest there's a risk of evidence being influenced, whether deliberately or otherwise, by the process of evidence being collected for inclusion in the witness statement. Number 7, the front loading of expense, which is routinely associated with the use of witness statements and the impact of that on parties. Number 8, where the circumstances suggest that ordering witness statements is likely to impact on the ability of the tribunal to ensure that parties are on an equal footing. This is an overriding objective point. And finally, number 9, there's a number of points that deals with the nature of the case. So, for example, the extent to which there are facts in issue, It says the use of witness statements may involve less risk to evidential quality where many of the key facts are not in dispute. Secondly, the complexity of the case, whether there are issues of credibility, whether the evidence, whether there's a risk that evidence in chief being given in writing rather than orally will impact adversely on the ability of the tribunal to assess particular aspects of the case. So really fairly restrictive, and again, maintaining that presumption that evidence in Scotland will be given orally in chief. But what happens if you're one of those very few cases where there is an order for witness statements? Well, the proceedings even then are different to how they are in England and Wales, because first of all, each statement should describe in an introductory paragraph how that evidence was taken. So, for example, the introductory paragraph should say that the evidence was taken face-to-face or remotely. It should set out whether there was an exchange of emails or documents between the witness and the representative, for example, to help the witness remember their evidence, whether there was an involvement of any other person in terms of obtaining that evidence, whether specific questions were put of the witness, so that's to avoid any leading questions being given to the witness. So that is very, very different to what we would have in England and Wales, where of course we don't have a paragraph such as that. There's also guidance on the content of the witness statements if they're ordered. So that focuses on avoiding ambiguity, and it also includes a reminder of advocates' professional obligations. There is then also guidance on when to take witness statements as read, and when or whether to allow supplementary evidence to be given. And again, I think this goes back to the Business and Property Court's point about obtaining a back to basics approach of obtaining truthful evidence in that witness's own words. And so if you see at the bottom there, paragraph 11, this is something that always frustrates me when I do cases in Scotland, but actually it does produce a much truer version of evidence from the witnesses that give evidence. So the position is unchanged in that all witnesses have to remain outside of the hearing room until their evidence is given, save in exceptional circumstances. So in case you haven't done a case in Scotland, if, for example, you were for a respondent and the claimant is going first and the claimant is giving their evidence, all of your witnesses will not be in the room with you. They'll be outside. They'll be in the waiting room. It's very difficult because if the claimant, let's say, obviously you haven't seen a witness statement from the claimant could say all sorts of things that you're not expecting, and you can't turn around or wait for a post-it to be passed to you. You just have to deal with it. In the moment. Sometimes you can ask for a brief adjournment, but really you have to have all of your instructions in front of you. Every question that you need to ask your witnesses needs to be done before the hearing, because you won't have a statement from them or indeed from the other side. So one final pitfall that I'd say that should be avoided in Scotland is that if you are representing a client in Scotland, even if there is no order for witness statements, and even if it's a case where you don't think you'll get permission, make sure you get a proof of evidence from those witnesses. I always insist on that. You need to know what each of your witnesses is going to say on every single point that you think might be raised, because if you don't, you'll be sitting there, or your barrister or whoever's doing the hearing will be sitting there cross-examining blind, really, because you won't have anything in front of you dealing with all of those points. And also it helps the witnesses in that if you've got your witnesses waiting in the hearing room for hours on end or days on end, going back to witnesses' comfort, if they've got a proof of evidence written down in front of them, they can read that, they can remember that they're not going to be criticised in Scotland for forgetting the odd date, but if they're an investigating officer and they took a number of steps on a number of different dates and a number of different allegations, it will help them to have that written down in front of them before they go into the tribunal room to give evidence. So as a final point, I would say that would always be helpful if you are either representing someone in Scotland or instructing an advocate to do that. So I think that brings us to the end of our Law with Lunch. We do have a bit of time for questions if anyone has any questions, or I think on the last slide, Bethan, we've got our email addresses. if you want to get in touch with either of us, if you've got any questions in relation either to what we've said today or in relation to any specific points that you have with drafting of witness statements in general. As I said at the outset, this webinar is being recorded. It will be on the website if you want to watch it again. But if you've got any questions, I'm just checking the chat room. I can't see any. So unless there's any questions, thank you very much. And I see some familiar names in the attendee participants box. Yes, and feel free to contact us if you have any questions arising out of today's talk. Shall I stop the recording, Bethan?
Yeah, I think so.
Any questions? Okay. Right. Stop recording.